face already.
No.
Okay, welcome everyone. Good afternoon to you, to this lovely Saturday afternoon. Thank you very much for spending your precious time with us. And my name is Karine. I'm actually the Rockville Senior Estate Planner from Johor Bahru. And our speaker for today will be Mr. Chong Mok Yong. If some of you have not joined our session before, Mr. Chong Mok Yong is actually our 6th-time president in Rockville business. Yeah. What does it mean, president? President means that he is the top of the whole estate planner in estate planning business. So he is number 1. And for a person to continuously to have 6 times as a president, I think till today, no one can break his record. So thank you very much, Mr. Chong. And yes, afternoon, everyone. Welcome back. Let's let's going to start today's session. Yeah. Mr. Chong, with your experience for all this year, there are some questions that our friends want to ask. Yeah? So for today's session, we would like to ask is, if my father has a sole proprietor business known as ABC Trading, can I use the same company name when I take over from his will, what he has written, he passed the business to me? Can I use back the same name or not? Mr. Chong?
Okay, for sole proprietor, it's very different from like Sandran Berhad or partnership. So a sole proprietor belongs to an individual. So when your father or somebody who write a will and will away the business, the sole proprietor business to a beneficiary, basically he is willing away the asset of the business. The asset of business meaning the asset and the tools of the business. For example, the bank account under his name, the tools, the machinery, the asset in the company, give it away. But he is not able to will away the company name to you because the company name, ABC Trading or whatever, dies the moment he passed away. So in the will, he merely distribute the asset of the business, maybe it's the tools of the business, the machinery, the stock, in the business, everything to the beneficiary in the will. So when the beneficiary take over this asset, the tools, the machinery, the bank's account, everything, the beneficiary need to register a new name. Cannot use back the old name anymore because the old name is together with the with the owner. Unlike those like in the Sandran Berhad share, when you will away only a portion of share to holding to somebody, the company is still running as normal, just that there is a change of ownership for a certain percentage of the share. So that company can still run. But in the case of sole proprietor, it's not able to continue with the same name.
Okay. What about for partnership, Mr. Chong?
Partnership you can, provided there is enough people there. For example, if you are having 3 partners and one partner pass away, the partnership still continue to use the same name, but not in the case of a sole proprietor.
Okay. That means for partnership, we can actually continue with the business. However, with sole proprietorship, despite the father, whoever give us this business, we can only take over the asset in the accounts, okay, or the tools or machinery or the property, whatever thing, except the name of sole proprietorship registered. So for sole proprietorship, the business will die with a person's name registered under sole proprietor.
Yes.
Yeah, okay, that's great. So yeah, welcome back. I think there are some newcomers. Today, our session is talking about business. Just now, if you missed our session, we asked about for sole proprietorship, if a person pass away, can he will away and continue with the name of sole proprietorship, let's say ABC Trading? The answer is no, okay? Sole proprietor can only will away the asset, the bank account, the tools or whatever thing with the business that can pass to a third party or the son or the daughter. However, the name registered under sole proprietorship, it will not be able to continue with the business because sole proprietorship business will die with the person. Yeah. Now, coming back to this, we will have other question. Meanwhile, my friends, if you have any question, please prepare your question. Later, you can always post up the question. Our expert, Mr. Chong, definitely will answer whatever that you post to us. Okay. Now, second question. Due to loan approval issue, yeah, my uncle has a property which he purchased, but registered in a friend's name. They may using other people's name to buy a property lah. Can my uncle ask his friend to will back the house to him via a will? Is this workable or not? What is the best method to be securely? I pay money, but the property is not registered under my name, but under my friend's name. How can I actually ensure the money that I pay, I can actually get back the property under my name?
You see, this is basically a proxy case. What I see here is a person has money, but he is using somebody's name to acquire an asset, and he pay for the what they call that, the loan or whatever, correct? And he wished to take back the asset, but he asked the guy that owned the asset to will away via a will. Okay, via a will to will back to him can be done. But however, from practical point of view, it's not advisable, because the friend that with the name registered on the asset can change the will. See, he can change the will. So today he might have written a will and show you that, oh, I put down here that if I die, I will away this property to you. But tomorrow he can just change the will. So that is not so practical, not so secure. But I would rather recommend you to do a document called Declaration of Trust. How it works, the Declaration of Trust. Basically, ask this friend who is still friendly at this point in time, prepare this Declaration of Trust, and under one of the products under Rockwell's our products, and the Declaration of Trust will mention that he appoint Rockwell as the trustee should something happen to him. Okay, meaning to say that if something happened to him, he will give the power of attorney to Rockwell, okay, to transfer this asset back to the original owner, okay, via a power of attorney. Okay, this should be the document that the friend suggests to do rather than do a will. And because in this situation, when you do a declaration of trust, in fact, there are several events. You know, you can mention, for example, he can mention that if he is DPT or he is dead, die, okay, and he is a coma or whatever reason, then this property, then Rockwell trustee will exercise the power of attorney given by this friend and transfer those assets back to him. Okay, this will prevent this asset from falling into his will, his estate. However, I would like to suggest that instead of just putting the event like death, or coma or TPT, should put another event called full settlement of the housing loan, if the housing loan is not fully settled. Because why should you wait for him to die only you transfer the property? You should transfer the property the moment the housing loan is fully settled. So put an additional event called settlement of the housing loan. You see, because he's paying the owner is paying the housing loan. See, that's why now cannot transfer. And with this document, I would advise that this person who is the beneficiary in this will, in this declaration of trust, put a caveat in the land office on this property, because he and this friend has no relationship. It's not a family relationship, just a friend relationship. So he couldn't put anything in the what they call the land office, or put a caveat, because there's no good relation, not a husband and wife or father and son you can put. But now with this document called Declaration of Trust signed by him, then this friend, this uncle can actually get a lawyer to put a declaration, put a caveat on the property, so that the property cannot be transferred name to anybody without his knowledge. So I think Declaration of Trust should be the document used in this situation rather than writing a will per se. Oh,
Yep. Ladies and gentlemen, do you aware that will is a document that very crucial upon our passing? That means once a person pass away, whatever under this person's name need to be transferred via your wishes. Only this document can apply. If a person is still alive, yeah, for this uncle, he is due to age issue or whatever, financial, maybe the income is actually not up to date, that cannot take a loan from the bank. He requests a friend, okay, to buy a property under a friend's name. The loan is of course under the friend's name because he is able to get the loan, but this uncle maybe due to age, he can't actually apply for the loan. So in this case, uncle actually pay the money for the property, but no name. You pay to a third party, the property buy under a friend's, but it's not under your name, but you pay the money. What kind of security that you need to take back? So in this case, what we discuss is another document. Instead of waiting for him to die to pass this asset to you, it's too long because nobody will know who will go first. And a will is actually during your lifetime, you can always make changes. So there's no security at all. But declaration of trust is a document, both parties under mutual understanding. Okay, uncle's friend need to do up a document called declaration of trust. Yeah, and the declaration of trust is spelled clearly upon demise or upon the loan fully paid. This property will transfer back to uncles. Okay, so uncle will have this security come into picture. And of course, because uncle and the friends, basically they have no relationship, they cannot simply go and put a caveat. But with this declaration of trust, this particular document, he is actually the beneficiary in it. Yes, he can use this document to go to the land office, get a lawyer to help out to lodge a caveat in this property. When you lodge a caveat in this property means you have interest in this property, he cannot simply sell off the property. Okay, so ladies and gentlemen, if you do have a lot of friends, invest property via third party's name called proxy. You must always ask your friends. The knowledge is actually very important. How are you going to protect your asset? You cannot simply get a third party to buy a property under third party name and you pay for the money. So end of the day, there's no security, and end of the day, a lot of argument. No way that the other party will give it back to you. Yeah, so knowledge is very, very powerful. Okay, now today we are going to say about what if, Mr. Chong, I have written my will myself. If I lost my will, yeah, I don't know where I click. Can my family member use the copy of my will? It's a photocopy, yeah, to claim my asset, to apply for the grant of probate in this case, original missing.
I see. Generally, you can't use a photocopy or a certified true copy by anybody to apply grant of probate. What the High Court need is still the original copy of the will. So it's very important that you must keep your original will, in good condition. And when the time comes, your executor, one of your family member, will have to use this original copy to apply the document called grant of probate at the High Court. Oh, okay.
Okay, so ladies and gentlemen, will is actually a very, very important document. Yeah, only original will be applied whenever you want to apply for the grant of probate. This is really exception cases, yeah, because the whole process done by rock will, the whole process from the retriever, who is the clerk, meeting this person, how she will actually withdraw the will, all the procedure is actually indicated very clearly. And happen to be the car being smashed, everything gone. She also need to make a police report. So from the beginning, she stepped into Rockwell's office until the car smashed and the whole thing gone. The whole police report is actually submitted, and via this lengthy report, I think court say yes, this is a genuine cases, and of course she actually able to do something in this thing. So Mr. Chong, we have a question. Is Laura the executor in the will? why didn't the main wife is actually being mentioned?
Laura is the executor in the will because she's the only one so-called educated among so many of them.
Okay.
Because the wife actually, as I say, is paralyzed, cannot really move, not so mobile. So Laura is the one that helped to do the transfer. In fact, she transferred all the thing according to the will to the respective member in the family.
That means she's also doing her part. At the same time, she's also doing a fair share to the first family lah.
She didn't take whatever extra lah. She do. I know she had done the whole thing already, because the probate was granted and she transferred the those other property to the parent, to the wife and the children, the two sons.
Okay, so Mr. Chong, since will is a very important document, yeah, it need to be. Does this will that you have written need to be stamped? What happened? Our will in rock will, is it need to be stamped as well to be valid?
Will is actually wishes, okay, under the Probate Administration Act. Will actually is not a contract, okay, it's not a contract. In a commercial law, when there is a contract, it has to be stamped, sealed, so that the transaction is legally binding. Okay, if you were to study law of contract, okay, under the law of contract, they say that there is a contract if there is something called, the term called consideration. What do we mean by consideration? For example, when you rent a house to a family, to a tenant, the tenant give you 600 ringgit per month, okay? That 600 ringgit constitute consideration, okay? So when there is a consideration, there is a contract, and that's why the tenancy agreement need to be stamped, okay? Because there is a contract. But however, in the case of a will, there is no contract, correct or not? Because there's no consideration, sorry. Because when you write a will and say, I will away my house to my wife, or I will away my money in the bank to my son, the son or your wife do not give you anything. There's no consideration given by the beneficiary. So as such, this is not a contract. And because it's not a contract, it not need to be stamped, and it is not a commercial transaction. That's why all the will in Malaysia don't go for stamping or go for commission or oath or whatever. Just make sure that the will is written properly and signed properly, documented, and put one side, and then that's all. That's what need to do. No stamping at all, because it's not a commercial transaction and there is no consideration from the beneficiary to the testator. Okay.
So, Mr. Chong, since will is such a very important document, some people basically they will write and rewrite their will. So until don't know which one is the. So if the family come across with so many wills, which one will apply? Is considered the valid will in this case?
Under the Probate Administration Act, actually the last will prevail. So only the last will that will be recognized. If not, those earlier one will be reverted, because on the top of every will, it will say that I revoke earlier will. So they will the court will look at the date of the will. Which one is the last one? That one will be recognized if there are so many wills suddenly appear.
Okay. Sudden, I have one question. Yeah.
Yeah.
If the person have earlier on, the will is actually through signing. The latest will is actually thumbprint. Yeah. If a family dispute come into picture, this family say, okay, he write this will is during his signing. Your will in your hand is actually thumbprint. So come to dispute, who can win the case?
Whether a person is using thumbprint or whether a person handwritten signed the will, it doesn't matter. Okay, it doesn't matter. The most important part will be on the documentation of the will. That means to say, when the person do the signing of the will, either via a thumbprint or handwritten signature, whichever method, it doesn't matter. As long as the two witnesses witness and see him that he has signed or done the thumbprint in front of them. That should be the more strong ground of whether the signature is whether his signature or not. In fact, sometimes I tell some customer who panic when they feel very stressed when they sign the will. You know what I told them? I said, Auntie, if you are not sure how you sign your signature, you can draw a fish, draw a coconut tree also can. You know, the coconut tree or the fish that you sign now is your signature, and I will recognize it, even though your bank signature is different, you know, because at that point in time, you put your hand down to sign in the form of a fish or in the form of a coconut tree. That is your signature. The witness you, that's good enough already. So whether it's by thumbprint or by handwritten, actually doesn't matter. Not say that which one is better or whatever. But the more important thing is the content of the will. Make sure that the content of the will cover all angles. For example, if this person think that he is not leaving anything to a certain person, you know, it's better to put a statement say that I am CMY, not leaving anything to this son or whatever. Or he might need to mention that certain reason why this son is omitted, you know, as far as the contents of the will is concerned. And on the documentation, when you sign, make sure that the two witnesses witnessing him sign the will or thumbprint the will on the same table. That will make sure nobody can contest already. Oh, okay.
Okay, thank you so much. So ladies and gentlemen, writing a will is very important. The content of the will also very important. The last date of the will supersede the earlier date. Yeah, and more importantly, who is your witness? The two persons will testify, witness your signature. That when you're signing the will, you are aware what you are signing. You are not forced by someone, or you are actually not forced by someone to use your thumb to thumb on the document. Because when family dispute come into picture, these two witnesses, they need to present themselves to the court if need to. Yeah. So ladies and gentlemen, knowledge is actually very important. Writing a will, who is your witness? Okay. How's your clause in your will indicated very clearly whether this is your last will and testament also play a very, very important part to avoid any family dispute in the future. Yep. If you have not written your will, whoever invited you to join our session, please spend some time to do something about that, because this is pertaining to your asset. This is pertaining how you want to distribute your hard-earned money to your loved one. Yeah, all the family dispute can be avoided. Yep. Okay, coming back to another question. Okay, a friend of mine, basically he has a business, and the business actually generated 3-4 million yearly. He want to do something like, I want to give to my children, but end of the day, I don't know whether they can actually handle or not. Or eventually, I want it to be a longer period, okay? And the business can actually generate income for my next generation to use. Yeah, but my children will be beneficiary of the income in this level. So is this writing a will is the best option, or trust, or any other instrument in this case that a customer's business can be prolonged, at the same time can generate income for the next generation? Yeah, Mr. Chong.
Well, basically what you're trying to tell me is the customer wish to hold the legacy for many generations to come.
Many generations, because the business is making money.
Okay.
If I actually give away to them, I don't know whether A going to continue the business or sell off the business or not. Okay. So these are their concern.
Okay, yeah. If you were to write a will, then it's not encouraged, because you know why? If the business is good and making good money, and if you were to will away to your children, okay, your children will get old, and then they will will away to their own children. So you can find that there's fragmentation in the shareholding. When there is fragmentation, it allows to take over by some other people. If somebody come in and buy, you know, certain amount of share from this person, that person, then they can accumulate the shareholding, and then they become the shareholder. So if that is the case, I would recommend that this person to do a foundation, a family foundation, especially in Labuan or any other offshore center. Basically, when you do a Labuan foundation, family foundation, basically the owner, the founder will part all the company share in the foundation. And in the foundation, they will be just similar to a company, whereby like in a company, our company, we have board of directors, and we have shareholders and all those things. But in this situation, he can park into the foundation, and when you park into the foundation, the children will not be able to own the ownership of the share of the company. So the children can also form part of the foundation, being one of the consultative committee, just like our board of director. So they can actually run the foundation, and the foundation will own the share of the company, and the company will be running by the children or some professional people. So in that case, whatever profit that generated from the company will go back to the foundation, and from the foundation will distribute those dividend or income to the beneficiary, which is his children. So when you have a foundation set up, the assistance of foundation is perpetual. That means it will be forever. In fact, it can even cross 80 years, like trust, trust cannot cross 80 years. This one is perpetual succession. So foundation will be a good vehicle for him to consider, and the children will be part of parcel of some of the consultative committee in this foundation. Maybe let me just show you the structure, okay, how it works. This is a foundation structure of foundation. The founder, which is the owner, they will draw up a charter or article. This is just like a company memorandum or article, article association, and they will appoint counsel. In this situation, they will be appointing some family member to be counsel, and officer are the people that will be running the company, the foundation, and the officer will have run this foundation, and all the business that under this Mr. Wong will be part under this foundation, and whatever profit dividend will go back to the foundation, and the foundation will pay all the distribute the income to the beneficiary. Okay, so in this way you can see that the children will not be able to own the share already. So it's all part under the foundation, and the children can also be part of the council member, consulting member, and officer that will run the foundation. So if that is the case, the business can continue to produce income, and all will pass back to the income will pass back to the foundation, and the foundation will be managed by the officer, which could also be the children, and they will decide how to distribute this income to the beneficiary. So with this thing put in place, this company can forever be around, and there won't be any change of what they call that, the shareholders. It will be all in the foundation. And also, good thing about the officer here or the council member here, they were able to manage whatever that income that they receive, whichever way they want, and distribute accordingly to the beneficiary. And the charter here will be the rules that the uncle, the founder, have put in. Maybe he say those with surname Wong would have additional 10% of the income, my daughter-in-law or whatever, all this will be getting less or whatever. He can put all the conditions here, and he can also put give power to the council to make sure that beneficiary who are actually qualified to get it will get. Because some beneficiary over the years, maybe some gambling, become gambler, or maybe some will be bankrupt, So the council here can appoint, can manage who can decide who can get or who cannot get those income. So basically, this is a structure for the customer to consider. Oh, okay.
So, Mr. Cheong, who will be the counsel in this case?
The family member. The family member.
Can the counsel also be the beneficiary?
Can. No problem.
Can be the same group of people.
Normally this family private foundation, normally they will also include some professional people like accountant or independent lawyers, so that they can make a better decision. And these people, just like our company, Rockville or any other company, you invite some independent director, quite the same lah. Okay.
So the benefit of foundation basically is the succession planning for continuity lah.
Yes. So that you don't have to will away your share to your children. This one 20%, that one, but they will also have to will again to your children or halfway and get fragmentation. So when you do a family private foundation, there won't be any fragmentation of the company already, because all the share is under this foundation already. Okay.
So for this foundation, what will be the asset to park in here?
The asset to park in here depend on the size of normally for Rockville practice. I think if you are talking about 50 million should be a good figure already. 50 million and above should be a good figure already.
15 or 50?
50.
50. That means the company asset is more than 50 million.
Yes.
It's worth to consider to start a foundation instead
Yes.
of using this asset to give away to son 1, son 2 like that. Because as long as you give away your share via a will, the company eventually the company share will be fragmented among 2 family already. What if one of the son is passed away? Then we'll go back to another the son's children again. That means the share will be splitted among all, then fragmented among the whole family instead of still lumped into one business. Am I right to say, Mr. Cheong?
Yes.
Yeah. So, ladies and gentlemen, if you have such customer or such friends around you, I think being friends or being some advice given to them, if they need all these proper tools in their asset planning, please look for us. Rockville already in the business for 27 years. Yeah, we have been helping our client, okay, to plan ahead their asset planning. Because end of the day, if you don't plan it well, you will actually, if you don't take charge of your money, who is going to take charge? The government will come into the picture.